We were working with a lawyer who practiced up in Thunder Bay. And every once in a while, he would have a personal injury claim or a case of some sort, and he needed some help, and we would act as counsel.
Called me and said, I've got this really interesting case, and I think it's a big one, and it has to do with Indian residential schools. And by that point, there had been a Royal Commission on Affairs in the Residential Schools that had been highly critical of the government and the churches.
In British Columbia, they were doing individual claims, and lawyers out there were bravely going to court and suing the churches and suing the government and trying to get compensation on a case-by-case basis. At some point, around that time, class actions were starting up, and the Class Proceedings Act was passed in Ontario and in other provinces.
Ultimately, having heard the story from a number of people, we decided it would be appropriate to start a class action alleging that all of the students that went to these schools were mistreated. There was an institutional child abuse element that could be advanced through a class action.
We were thinking of advancing to make claims, not only for persons who were abused in residential school, but for persons who simply attended residential schools and suffered the common harm of having their language and culture denied.
We decided that we wanted to bring a national class action, and we started a case called Baxter versus Canada.
Two brothers from Northern Ontario who had attended residential schools.
After we started the national class action, we faced quite a bit of resistance from individual lawyers throughout Canada who have started dozens, if not hundreds, of individual cases on behalf of victims.
The idea started to circulate that using a class proceeding and getting people like the Assembly of First Nations and all of the stakeholders involved might be a way to reach a resolution. Everyone has to buy into this, including the politicians.
After much discussion and deliberations, we ended up forming a national consortium of 18 law firms working together to advance the national class action.
In the court cases, it's often referred to as Fontaine against Canada, but it started as Charles and Elijah Baxter against Canada, and it was our class action. It was a tremendous negotiating process across Canada.
As a junior lawyer, I was the middle person for the whole national consortium. I personally attended every negotiation session from Vancouver out to Montreal over the course of about a year.
Our office was very instrumental in all of that negotiating, very instrumental in the drafting of the agreement, very instrumental subsequently in administering the class action settlement.
It provided compensation for everyone who had attended the schools on a sliding scale. It provided a mechanism for dealing with the sexual and physical abuse claims, of which we really didn't know how many there were.
We helped thousands throughout Ontario and throughout Canada receive compensation for their horrific experiences at residential schools.
The total damages paid under this residential schools case were around $5 billion, so it eclipsed all previous settlements by multiples.
It was a privilege and honor for Thomson Rogers to be involved in it. This was what law is all about, fighting on behalf of people who have been victimized against very big entities, here the biggest possible being the Government of Canada.
It was a huge step forward for the relationship between Aboriginal people and the Canadian community.